Good morning, everyone.
And I'm like, oh yeah, great.
Good morning. Okay. All right, I think we got everyone's attention. All right, good morning. This is the Palm Beach County Zoning Commission. It is January 11th, 2024. Unbelievable. So can you do a roll call, please?
Good morning, Commissioners. Chairman Stowers,
Here?
Vice Chair Pavlik, Commissioner Kern,
Here.
Commissioner Kelly, Commissioner Groman, Commissioner Scarborough,
Here.
Commissioner Revis,
Here.
Commissioner Brumfield,
Here.
Commissioner Beatty.
Here.
We have a quorum.
We have a quorum. Great. Thank you. Opening prayer and Pledge of Allegiance.
Please stand. Lord, we ask your guidance today as we consider matters that will affect the safety and welfare of many people in our county. Help us to listen with open minds to matters that are important before us and to act on the matters that will benefit those who reside in our area. Keep our minds open and alert, our hearts compassionate, and our comments charitable. Amen.
Amen.
Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The Zoning Commission of Palm Beach County has convened at 9:00 a.m. in the Vista Center, Ken Rogers Hearing Room, VC 1W47, 2300 North Jog Road, West Palm Beach, Florida, to consider proposed applications and staff recommendations pursuant to and other actions the Palm Beach County Unified Land Development Code. The Commission takes final action regarding Class B conditional uses, subdivision variances, and Type 2 variances on issues and advisory recommendations on other requests. The Board of County Commissioners of Palm Beach County will conduct a public hearing at 301 North Olive Avenue, West Palm Beach, Florida, in the Jane M. Thompson Memorial Chambers, 6th floor, at 9:30 a.m. on applications not subject to Zoning Commission final action. Zoning hearings are quasi-judicial in nature and must be conducted to afford all parties due process. The Board of County Commissioners has adopted procedures for conduct of quasi-judicial hearings to govern the conduct of such proceedings. The procedures include the following: any communication with commissioners which occurs outside the public hearing must be fully disclosed at the hearing. Applicants and persons attending the hearing may question commissioners regarding their disclosures. Such questions shall be limited solely to the disclosures made at the hearing or the written communications made a part of the record at the hearing. Any person representing a group organization must provide documentation that the person representing the group has the actual authority to do so regarding the matter before the commission. Any person who wishes to speak at the hearing will be sworn in and may be subject to cross-examination. The applicant and county staff may cross-examine witnesses. Any other persons attending the hearing may submit cross-examination questions, including follow-up questions to the chair who will conduct the examination. The scope of cross-examination is limited to the facts alleged by the witness in relation to the application. Public comment is encouraged, and all relevant information should be presented to the commission in order that a fair and appropriate decision can be made. Proof of publication?
Yes, we do have.
Motion to receive and file.
Second.
We have a motion by Commissioner Scarborough, seconded by Commissioner Kern. All those in favor say aye.
Aye.
Opposed? Swearing in.
All those wishing. Use a mic. All those wishing to testify or speak on today's items, please rise and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you.
Thank you. Any amendments to the agenda?
Yes, we have amendments to the agenda. We have an amendment on item number 2, DOA 2022-509, Atlantic Christian Academy. We are amending portion of the staff report. There are corrections on all petitions, condition number 2, in regards to the representation of the Board of County Commissioners, not the Zoning Commission. And condition number 19, engineering conditions. The conditions, it's indicated as amendment, but should have been completed, so we're eliminating language and adding a trailer to that respect. There is also amendment to item number 3, ZVPDDDOA 2023-00955. That's John's PUD. We are amending portion of the staff report. Variance condition number 3, we're eliminating the word property owner at the end of the condition. Also, we are amending landscape conditions regarding perimeter landscape along the property line on PUD A and B. Compliance condition number 1, some cleanup, engineering condition number 11 in Exhibit C3, that's the noise mitigation. We're adding language to the condition. Also not in your add delete, but item number 4, that's Pine Trail. It's not in the add delete, but we want to bring to your attention that staff is working with the applicant on modification of the landscape condition number 1 between the Zoning Commission and Board of County Commission.
All right, thank you. We do have some comment cards. So there's any request, well, first, I guess, is there any items to be pulled from the consent agenda? Yes, sir.
But before we get to that, can we do approval of the minutes?
Oh, I'm sorry. Oh, I moved along. Sorry. I have approval of the minutes.
Motion to approve the minutes?
Second.
Motion by Commissioner Scarborough, second by Commissioner Rivas. All those in favor say aye.
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 Opposed? Okay. Thank you for that. All right, so we did the add and deletes. Any items to be pulled from the consent? We do have some comment cards. Do we want to hear those now? Or do we want to?
This portion is just approving the agenda. Once you get to consent, that's when you can actually hear the
Okay.
comment.
Okay. So then I'll have a motion to adopt the agenda.
So moved.
Second.
So moved by Commissioner Beatty, seconded by Commissioner Scarborough. All those in favor say aye.
Aye.
Opposed? Disclosures. Any disclosures?
No disclosures.
No disclosures.
I spoke to the applicant on item number 5 briefly yesterday.
I spoke with the applicant on John's PUD.
Okay, and no disclosures. Conflicts or recusals?
None.
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 And none. Okay. Any postponements?
There's no postponements.
Okay, withdrawals? Any withdrawals?
No withdrawal.
Okay. All right, so now we're on to the consent agenda. So this is where, read the comment cards?
Yes, you can hear the comment cards, and based on the outcome of that, you can decide to pull something or otherwise vote.
Okay, we have, the 5 cards on item number 1. All are in support of, and no one wished to speak. Item number 3, we have 1 card opposed, and he wishes to speak. Robert Zoli, I believe? Zoller. So you want to pull this from the agenda, or do we want to let him speak? And
Well, I think,
We can-
let's hear him speak.
We can just hear the card
Yeah.
first and then make a determination.
Okay.
Is that possible?
Yeah,
Yep.
if you want to step up to the microphone over here, please. State your name and address for the record.
Good morning. My name is Robert Zoller. I live at 19975 Villalante Place. I live on the north border of the Johns PUD. I just wanted to start with a question, and then I had my comments. And I heard something mentioned about landscaping. That was one of my questions. I see that one of the items is to build a larger wall on the berm on the northern border. I'm not against that at all, but in my understanding, in the original plan, there was going to be landscaping. Well, let me back up from that. With this wall, will there be room for Lake Worth Drainage District vehicles and other vehicles to maintain the canal that exists there?
Okay. Is that your question?
That's one of my questions.
Okay.
My other question is that in the original plan, and that's obviously very important to me, given that I live on that canal. The other question is, the original plan, there was landscaping in addition to the wall. There was a description of palm trees, et cetera. Is that going to still be there, or am I just going to be staring at a concrete wall? That was my second question.
Okay. All right.
Yeah.
Are you, so I'll bring that to staff. Staff, can you assist with that question?
Yes, the easement is going to be always open, the easement should be there, and the applicant has provided not only the required buffer, there is going beyond what the code requires, so it's going to be landscape on both sides of the wall, so you won't be seeing the wall. You should,
So landscaping will be
There-
on
there
both
will be
sides? So you won't be
enhanced-
looking at a blank?
yes, there will be an enhanced landscape. We have, the staff report indicates what type of plants and shrubs and trees are planting, and when staff analyze it, we agree with the applicant, they are providing more than what the code requires, so there will be enough landscape to screen the wall.
Okay. Thank you. That answer your questions?
I believe so, yes.
All right.
The remainder is my comment on the rezoning of the 70.35 acres on the other side of Lyons Road. And my immediate response is, you have got to be kidding me. This area is so overcrowded now. The infrastructure is so overloaded. And it's not just, there's and you know better than I do, that half a dozen other developments in this area. I mean, there's going to be so much overdevelopment, and this is just adding to it. And this area cannot support this. The existing PUD only has two accesses, one on Lyons and one on 441. Now, I'm assuming there's only going to be one access for this new area. There's a high school right there, and I live this reality. And the overcrowding on the roads is already excessive. And this isn't the only development. Okay, you can't look at this in isolation. There's I'll just say uncontrolled growth. There's a word for it. It's called cancer, and it kills. And it's this uncontrolled development in this area is killing this community. And that's all I say. Thank you.
Thank you very much. Okay. Any other comments? Mr. Commissioner Beatty? Nope.
No comments.
Okay. All right. At this point, is there?
Oh, one thing here.
Yes, sir.
We did, I think all of us got this Christmas card, but I'm not sure this item is on the agenda.
It's not.
It's not? It's next time?
No.
Okay. Never mind.
Okay. With that, does anybody have any requests to pull any items from the consent?
Nope.
No? Then I'll entertain a motion.
Motion to approve the consent agenda as amended, and that the variance meets the ULDC standards.
Second.
Motion by Commissioner Scarborough, seconded by Commissioner Kern. All those in favor say aye.
Aye.
Opposed? Okay. Thank you.
All right, so, moving on to the regular agenda. We have ZV 2022-1890 GMBC Warehouse. This item is a continuation from the previous hearing where the vote was a tie vote 3-3. We were going to turn the microphone to the applicant for a brief presentation for the benefit of the commissioners that were not here, and then to land development.
Sorry.
Hi, how are you? Good evening, Mr. Chairman, members of the board. My name is Bonnie Miskell. I'm filling in for my law partner, Scott Backman, and I know there was a presentation done, but some of you may not have been at the last meeting, so we're going to try to go through it succinctly and as briefly as possible. Okay. There we go. So my name is Bonnie Miskell. I'm here on behalf of the applicant, GLMC Group LLC, and we are here this morning requesting a subdivision variance to allow access from a 40-foot private street. This is an aerial showing you the property in question, which is identified in red, and the surrounding property. It's on the south side of Hypoluxo, between High Ridge and Congress, and it is on a 40-foot street, which is Thompson Street. That's the street in question. This is a blow-up of the immediate parcels around the property and the property itself, again, south of Hypoluxo. There is a canal that divides these properties and this street, the uses on the street from Hypoluxo, so there is not any direct frontage on Hypoluxo at this point. Thompson is a private road, and it has, and we'll get into it in more detail, but the parcels to the north of us are commercial, and they are developed with an advanced auto part. And we're going to, again, the variance is a subdivision variance from Article 11, Table 11E2A2 to allow access from a 40-foot wide road easement in lieu of the minimum access from an 80-foot wide publicly dedicated local commercial right-of-way. And the reason that we're having to ask for this request is the commercial use would require 80 feet. This parcel has no other rights of access. On the west side is a PUD in the city of Boynton, and there is, again, we are divided by a canal to Hypoluxo, and there's a canal on the east side of this subdivision. These are the land use and the zoning maps. You see on the left side the land use. There's a little history as associated with this land use as well, but they're commercial land uses, CH5, and surrounding that to the north, northeast, and east are CL5, and then residential MR5 to the south. The zoning for these the red parcels are CG, commercial general, and residential RS in yellow. So the history on this parcel is a really old parcel. And it was, the land use designation is a designation that doesn't exist anymore. It was C5. In order for it to fit into the current 1989 future land use map atlas, a determination had to be made. This is the letter with that determination. And it was determined to be analogous to a CH5. So that is hence why we have that designation on the map. This lot actually, as I mentioned, is a very old lot. It has existed in its current configuration since 1969, prior to the adoption of the county subdivision regulations. And this is a determination, the letter that you're looking at is from Scott Canner, and it was determining this as a legal lot of record. Again, been around for a long time. This parcel's been around before the land use designation that we have today, and it's also been around prior to the subdivision regulations, which were much later. So, okay, thank you. Sorry about this. Let me skip ahead now. So, it is an unusual scenario here that on a 40-foot private street, there'd be a portion of the street commercial and then the balance of the street residential, particularly with singular access to Hypoluxo and the singular access being a private road. But again, old subdivision, these are existing conditions. They predate probably all of us on this ZCC. The parcel immediately to the north of us is a developed parcel, and it's developed with an advanced auto. By the way, this is not a use request. These uses are approved. These are not setback requests, open spaces, or any other code requirements. This is limited to whether this parcel, through a variance, will be allowed access on the only street that it has access to, which is a 40-foot parcel, and not the 80-foot that would otherwise be required. This parcel, the Advanced Auto, was developed in 1996. It accesses a 40-foot. They did not dedicate additional right-of-way. Had they dedicated additional right-of-way when they came in 1996, they would have been required to expand it to the 80 feet that you are required to have for a commercial use. They did not do it. They are approved, they are operating, and we have to go through them to get to Hypoluxo. Again, if they had dedicated, I would not be here today because my client is prepared to provide additional dedications on its parcel so that it could otherwise meet it, but it can only do it on one side and it can't do it through that parcel. So I mentioned we're not asking for a use allowance. These uses that we are proposing are permitted by right. And this chart will give you an example of the problem. Any use that is in this zoning, which is CG, would require this variance. I have been doing this as a zoning lawyer for 32 years. I'm going into my 33rd. I've never seen a case like this. That's how special and unique it is. There has never been a parcel that I have come across that could not build what is otherwise an allowable use, and certainly could not build an allowable use on a parcel that they're meeting all the requirements of the code. Never seen it. It is incredibly unique. And they are at a point where if the variance is not approved, they can't use the property for anything. It will sit exactly as it is sitting today without any use on it, undeveloped, unable to use what they are entitled to use by right, which is the use that they're proposing. So what we did here, just to give you an understanding of how this owner tried to minimize the impacts, we looked at the least intense use in the entire CG. The commercial general category has some pretty intense uses on it. And so we looked at what's the least impactful and what's the most impactful. And this is a list showing you of the trips generated. And what we did is our building, we're proposing 1,000 square feet of office and 7,640 square feet of warehouse, which we are willing to impose a condition, and I'll get into that in a few minutes, that we will not do anything more than that. And the AM and PM peak hours for those combined uses are 3 trips in the AM and 3.6 trips in the PM. All the other uses beneath it are also allowable and permitted CG uses. And so we did a comparison that if you did 8,640 square feet of those uses, how would we measure up? Are we more? Are we less? Are we in the middle? We are the least impactful. We are the lowest trip generator. We are the minimum use that we could have picked for this parcel that would be the fewest trips. And as you can see, the AM and PM range from 14 to 181 trips that would otherwise be on this road that does not meet the commercial standard. So, we'll get to the standards, but it talks about doing the minimum. We are asking for the minimum when you look at all the other uses that are in the CG. And we have committed to, under condition 4, that project trips will be limited to the equivalent number of trips generated by 1,500 square feet of small office and 8,000 square feet of warehouse. I want to point out that the CG has FAR requirements, and I believe the maximum FAR, and staff can correct me if I'm wrong, is 0.85. We're at, with this condition, 0.27. So we're not even maximizing or even doing 50% of what we would be allowed to do under the CG. Again, when you look at minimum, we're doing the minimum, and we are committing and willing to be subject to a condition that says that we will give up rights that we otherwise could have built on the site in an effort to be a good neighbor. So this is our proposal. This is what the building would look like. You can see the parcels to the north of us. And by the way, there is a single-family home on the east side of Thompson Across. That property was rezoned, I think, in the 90s. So it had been a commercially zoned and commercial parcel. That particular owner came in, and it may not be the same owner, but whoever owned the property at the time came in and asked to go single family. As a matter of fact, these commercial parcels, the 4, have been there for a very long time, and when you look at the tax rolls, they were here before any one of the homes got built on that site. They were designated, I'm not saying they were built, they were designated commercial before any houses were built to the south, or for that matter, to the east. So this is the street, and this is the canal that it has to cross before you actually get to any of the lots that are in the subdivision. It is currently developed as an 18-foot wide road. My client is committed to expand that, and there is a graphic, I think, that I can show you. So when you look at the standards, these are the standards that you have to look at, and you're not looking at it for uses, you're not looking at it for setbacks, you're not looking at it for open spaces, because we're not asking for variances from them. As a matter of fact, we exceed all the standards, which means we are doing less than we would be allowed to do by law. We only have to get permission to be able to access the only road that we have access to. And if that's denied, we have no access, and under Florida law, that is called a taking, because the government, through its rules, cannot deny all reasonable use of the property, and you would be, because we would have no reasonable use of the property. So anyway, these are the standards. I'll go through them very quickly. Special conditions and circumstances exist that are peculiar to the parcel of land or the structure that are not applicable to other parcels. The parcel to the north has access, and they are a much more intense use than what we're proposing. For example, our use will not have anything greater than a box truck on it. The advanced auto comes in with large semis, that is a challenging use of the area given the configuration with the canal and the street. We're not doing that. Special circumstances and conditions do not result from the actions of the applicant. My client bought a piece of property that is a legal lot of record that has been land used and zoned what it is, probably longer than, well, maybe not quite longer than I'm alive, but I was a toddler at the time, I think, when that happened. And the subdivision regulations that create the problem, that now say you have to be 80 feet if you have a commercial use on a non-plan right-of-way or road. And so that rule came in after this parcel was designated what it is, after this parcel was created as a legal lot of record, and certainly is subsequent to the rules that apply to this parcel that is in question. I'm going to lump the next two together. The granting of the variance does not confer special privilege on my client that denied by this plan and this code to other parcels. That and literal interpretation and enforcement of the code deprive the applicant of rights commonly enjoyed by other parcels. If you look to the parcel of the north, we want to do what they're doing. We're asking to do what they're doing. They're actually a lower designation of land use than we are. We should be able to do what they are doing. So we're asking to be given the same rights and privileges as our neighbor. And then this one is probably the most important. Granting the variance is the minimum variance that will make possible the reasonable use of the parcel of land, building, or structure. That's why I showed you the other uses and how we compare to them. We are the minimum that you could do on the site. And, by the way, if we don't get this variance, we're denied not reasonable use, we're denied all use. We cannot use the property for any of the permitted uses that are otherwise allowed under the land use and under the zoning. And then the last two, granting the variance is consistent with the purposes, goals, objectives, and policies of the plan and the code. It certainly is in this instance for a number of reasons that we've contained in our submittal, and your staff has agreed with us on that point, and granting the variance is not injurious to the area involved or otherwise detrimental to the public welfare. I understand at the last meeting there were some people that came up that live on the street that would rather this not be there, and I certainly appreciate and understand them either wanting a vacant lot or not wanting another commercial lot. But we're not asking you for the commercial use. We're asking you to use the only parcel that we have for access. And that is not a basis to turn this down. The question is whether we don't meet those on the board. I'm a zoning lawyer of 32 years. I have also testified at hearings, and also I am an expert witness in some court cases actually pending. I am an expert in my field. This is by far, and I have done somewhere between 50 to 100 variances in my career, the most compelling case I've ever seen. Because in this instance, when you talk about injury to an owner who has rights, this would take away the ability to use their property in its entirety for a permitted use when all other code provisions are being met. We're not asking for any relief on any other site-specific requirement. So we believe we've met it. Your staff agrees with us. Your expert staff agrees with us, and they have evaluated and reviewed all of your comprehensive goals, policies, and objectives, and all of your code requirements. I will close at this point. I'm happy to answer any questions that you may have, and I'd like to thank you for your attention and appreciate the time.
Thank you. Staff?
Mr. Chair, if I may,
Sure. Mm-hmm.
I feel the need to respond to just one thing. If you could leave that screen up there for a second. Those are the standards by which you must determine whether or not the application should be denied or approved. The evidence on the record should be sufficient, substantial competent evidence to support all of those criteria. Just one minor thing, the applicant did refer to a couple of times this being a taking if otherwise denied. Just wanted to point out that it's a little bit of conjecture and opinion on the applicant's part, and if anything that was said or any evidence presented supports a finding that these have been satisfied, that's fine. I just wanted to point out that specifically referring to it as a taking is conjecture at this point, and more of an opinion.
Okay, thank you.
Yep. Now I would like to turn the microphone to Land Development for their presentation.
She has the clicker, sorry.
Right here.
Okay, good morning, everyone. Happy New Year, by the way. My name is Vern Vaughn. I'm the Senior Professional Engineer in the Land Development Division. Bonnie Miskell had just completed a thorough project overview and background, so for this application, my presentation is going to be brief. This is a subdivision variance for SB 2022-1890 GLMC Warehouse. The site is located east of Congress, just off of Hypoluxo onto Thompson Road. On December 7th, 23, the Zoning Commission motion to approve failed with a vote of 3-3-0 because of the tie. The application was continued to this meeting. This 0.71 acre parcel with general commercial district zoning, commercial high with an underlining MR5 CH5 flu. This site is currently undeveloped. The proposed use is small warehouse with office, a 40-foot private ingress-egress easement with varied roadway width, 18 feet being at the narrowest point. The next exhibit just shows Thompson Road, the subject property, and its 40-foot wide private ingress-egress easement in red is the roadway. This application is for a standalone subdivision variance request to allow access from Hypoluxo Road onto Thompson Road, which is an existing 40-foot wide private ingress-egress easement. In accordance with the Palm Beach County ULDC Article 11, Table 11E2A2, Chart of Minor Streets, access is required from a non-planned collector, 80 feet right-of-way, and having 24 feet of pavement. So therefore, the variance request is for minimum legal access, as per ULDC Article 11E2A2, to allow access from a 40-foot private ingress-egress easement improved to non-planned collector standards. The variance is for 40 feet in width and access from an easement. Land Development did an analysis of the criteria, and as per Article 2, Section 2B7E of the ULDC, the applicant meets the 7 criteria. There were a total of 6 contacts from the public, 4 in opposition. At the last meeting, we heard the concerns of the board. Therefore, we coordinated with the applicant and added additional conditions of approval. Therefore, staff recommends approval with conditions including improved Thompson Road to non-planned collector local commercial standards, limiting trips to an equivalent number generated by 1,500 square feet small office and 8,000 square feet of warehouse use, and limiting vehicular access to a maximum 2-axle single-unit truck. There are now a total of 5 conditions of approval for the subdivision variance. Would the members of the commission like me to read all 5 into the record at this time? The first one states, prior to the submittal for final approval of the Development Review Officer, the approved variance and resolution number shall be shown on the final site plan. Number 2, at time of application for a building permit, the property owner shall provide a copy of this variance along with copies of the approved final site plan to the building division. 3, prior to the issuance of certificate of occupancy, the property owner shall improve Thompson Road from Hypoluxo Road to the proposed driveway connection and transition to the existing roadway section to be consistent with Palm Beach County standards for a non-planned collector local commercial roadway or as approved by the county engineer. This construction shall be concurrent with the paving and drainage improvements for the site. Any and all costs associated with the construction shall be paid by the property owner. These costs shall include, but are not limited to, utility locations and acquisition of any additional right-of-way. And this is prior to CO. Item 4, project trips will be limited to the equivalent number of trips generated by 1,500 square feet of small office, the ITE 712, and 8,000 square feet of warehouse, ITE 150 uses. Item 5, vehicular access to the site is limited to a maximum 2-axle single-unit truck, an SU-30. For those, SU-30 is just basically a single-unit truck, 30 feet long, 20 feet wheelbase. The applicant also has to work with Advanced Auto Parts to make these improvements within the easement on their property. That basically concludes my presentation. I'll be happy to answer any questions.
Thank you. Any questions of staff? Yes.
I apologize for
That's all
interrupting
right.
again. I just wanted to make sure we get it on the record. The conditions that were just read in are for illustrative purposes only. There are additional conditions, standard boilerplate conditions, and some other comments within those conditions that are all included in your staff report already. So I just wanted to make that clear.
Great. Thank you. Yeah, I wanted him to read that in case someone was watching, so, and not having the, the documentation in front of them. Any questions of staff?
Yes, Mr. Vaughn, on the condition to improve the right-of-way, does that include 24 feet wide pavement?
Yes, ma'am.
And how far does that extend down the road?
It will commence from the Hypoluxo access point to their entrance and then transition back down to the normal section in accordance with the design standards.
Okay. I'd kind of like to see that extend to their property line myself. That road, I don't know if you've visited that particular roadway or not.
Yes.
It is substandard. It is narrow, and I think it's been there since about 1969, it looks like, because it's not in good shape, a lot of cracks and all. So, I see trucks maybe pulling forward and backing in. I'd like to see that roadway improved all the way to the southern property line. Other question I had for you is drainage, stormwater drainage on the site. Is there requirement for positive outfall to the canal?
Yes, they have to, every project has to have a legal positive outfall.
Okay, so that'll be through that 15-foot easement on the back of
Exactly, yes, to the Lake Worth Canal.
the overflow parking site for AutoZone.
Exactly, yes, sir.
Okay. And another question for staff. They say they're going to agree to use it only for warehouse and office. What can go in a warehouse space, use-wise?
Well, on a warehouse space, you could use, storage of materials,
Right.
anything that.
Besides that, what can be in there? Can it be a mechanic shop go in there? Can it be anything else other than storage?
That would be a different use, and we'll need to have an approval.
So it would strictly be for storage?
Yes.
Okay.
Yeah, I think my concern on that would be woodworking, anything with noise, kind of a noise issue, right? I think, is that what you're alluding to?
Well, that was what I'm alluding to, yes. Is it, what can be in there besides just storage under the county code?
Well,
If you had,
I don't think the code talks about what things can be stored there, but it's just basically warehouse, just storage. Like if somebody want to do like some repair and maintenance, that would be a different use. And then the code also limits, those uses. They have categories for it. They have light and heavy. So it would be strictly for warehouse and storage.
okay, no manufacturing, no.
That would be a different use too. Manufacturing would be a different use.
Well, if they're gonna bind themselves to that use, I'd like to see the word storage in that,
All right.
warehouse storage.
That's fine.
There's no sewer access on Hypoluxo Road?
God bless you.
I see it's a commercial project, and we're putting a septic tank drain field in.
Let me just go over it.
And if they got to tear the easement up through there anyway,
Yes, I believe that's
why aren't they
correct.
putting sewer connection in?
I know that the Advanced Auto Part store has septic and drain field.
Right. But
Where's the nearest fourth?
is that available on Hypoluxo Road's question, on the
I
south
don't know At
side?
this point, I don't know.
Don't know.
Does the applicant, maybe the applicant's here, engineer
Yes,
would know?
we can answer that question. It is not available yet. It would be through the city of Boynton Beach in the future, but they have not extended it to this street, so,
So it's not in Hypoluxo Road?
no,
Okay.
it is
It's
not.
not available, yeah.
Okay. Okay, I think you answered all my questions. I drove down the neighborhood this week, went down, drove through the street, came back out. And I just don't think it fits in the neighborhood, even though it's a accepted use, approved use. I think the lot has a better use residentially than commercially, so it could be used. It's not like we're not allowing them to use it at all. So I don't feel it's compatible, and I don't agree that it is not detrimental to the public welfare that lives on that street. You have commercial trucks now coming and going, and I know you got it on auto parts, but not a lot. It's deliveries. So if there's kids living down there, there's no sidewalks to get out to Hypoluxo Road. It's even hard to walk between the road radius turn-in and the Armco barriers there. That's a real tight, congested entrance there. So I do like what staff did as far as addressing comments last time, and so I appreciate that if it does go forward, but it doesn't have my support. Thanks.
Thank you. Any other questions?
I do. I have
Commissioner
an
Rivas.
additional question. I think this is for Mr. Vaughn. You had mentioned in the conditions of approval that you want the applicant to work with AutoZone on the widening of the right-of-way. What is your contingency plan if AutoZone does not cooperate?
Typically, with a subdivision variance, we wouldn't require an agreement, but something, if the board wishes, we could be happy to add another condition of approval for an agreement to be obtained possibly prior to the site plan, but
So if AutoZone didn't cooperate, the widening to 24 feet of pavement probably won't happen, right?
I think I can interrupt here. The condition requires them to improve the roadway from their entrance to Hypoluxo.
yes.
Part of that will require the cooperation of the AutoZone owner.
Vance Auto.
So that's necessarily already part of the condition. They wouldn't be able to improve the roadway unless they got the cooperation. Is that correct?
That's correct.
So maybe clarify the language? Right, if they don't get the necessary right-of-way, they can't build the access to the standard.
It's in there.
It's
Yeah, that was
Right
one,
away.
It's already in there.
that was one of my,
Oh, go ahead, I'm sorry.
that was one of my points last time, was that they don't have the agreement in place with AutoZone. And without that, we're just wasting time here.
Yeah.
So that's another reason I'm not supporting this project, is that they didn't come forth with the agreement in hand.
Ms. Misko,
Commissioner, yes.
Thank you. Yeah, we are very much aware that we have suggested the condition that we are required to do it. So if we cannot get their consent, then we acknowledge that we will not be able to use the property as we've discussed. I would like to add, though, we've gone beyond simple negotiations with AutoZone. We are working out the details as to how that will work on their property. So we're much further along. I just don't have a letter to give you today. So
Yeah,
just
and
wanted
I'd have to
let
see
you
the
know that.
letter of agreement to
Well,
talk,
you-
you're a lawyer.
Well, you are protected. Your staff did protect you. As your attorney has said, there is a condition that says you either do it or you don't have it. So we know that, and we're conceding that point. And it is crystal clear the way it is written.
Thank you. Commissioner Rivas,
Thank you.
okay. Any other questions of staff? I do have one question. Is residential, single-family residential allowed in a commercial zone?
Well, I think they'd rezone it.
They would have to.
You'd have to rezone, right?
Right.
Yeah.
Yes, have to rezone.
Right, so it's not a permitted use.
No.
But you could rezone, probably go to multifamily also, and,
That could be a possibility, yes.
yeah.
Ms.
If
Misko?
I could respond to that as a lawyer, we simply couldn't just rezone. We would have to apply to rezone, and we'd have to get the will of the ultimate decision maker, which is the Board of County Commissioners. So it is not a given. It is a possible application, but in looking at legal rights, we do not have the legal right to develop a single-family house there.
Thank you.
You'd have to go forward with the process.
Okay. Any other questions of the applicant or staff? And we have no cards for no public comment, so I'll close this to board comment.
Mr. Chair, I think the applicant has already exhausted their responses, but now would be the appropriate time if they
Oh,
had
I'm
any
sorry, yes, any questions?
additional.
Yeah.
And thank you very much, and I do appreciate the time. These are always very difficult decisions, but your staff does a very thorough report in evaluating it. And these conditions that have been imposed are not typical conditions. We are proffering restrictions on our property to do less than the code says we could do. You've got the zoning code rights. And so we have really, really bent over backwards to minimize and to be the least impactful use on the site. While I recognize, and again, we cannot build a single-family home. We cannot build anything else. Right now, our option is get this variance so we can go forward with a commercial use or consider other, whatever remedies we may be availed by law. But we have no reasonable use of this site without this variance, and I just want to impress upon you of that. And in exchange for the right to use the property, we're agreeing to expand the road to 24 feet, which will not happen without us proposing that condition and being able to go forward. And we have no problem extending, as Mr. Beatty asked, extending that dedication all the way to the southerly point of our property. Not sure whether it will ever get expanded beyond that, but we're agreeable to doing that as well. There are a number of conditions that we propose that will make that road a better, safer place for everyone to use, and we're hoping that, you know, we've demonstrated that we met the requirements. And thank you very much for your time and attention.
Great, thank you. Any rebuttal, staff?
No.
Okay.
All
having
good,
none.
thank you.
All right. Okay, commissioners? Thoughts?
So,
well-
Mr. Chair, with no other comments, I'd like to make a motion to adopt a resolution approving item 5A.
We got a motion for approval from Commissioner Kern, second from Commissioner Brumfield. All those in favor say aye.
Aye.
Opposed?
Aye.
Aye.
Let's call the roll, please, on the vote. All those in, please call the roll for the vote.
Will do. Commissioner Kern?
Yay.
Commissioner Scarborough?
Yay.
Commissioner Revis?
No.
Commissioner Brumfield?
Yes.
Commissioner Beatty?
No.
And Chairman Stowers?
Yes.
I have a 4-2. Motion passes.
Thank you very much.
Thank you. Okay, so that ends our regular agenda. Comments from County Attorney?
I've said enough, no comments.
Thanks for keeping me straight, Scott. Appreciate it. Zoning Director?
In representation of the zoning director, no comments.
Okay, thank you. Planning Director?
No comments, thank you.
Okay. Executive Director?
Hi, I don't know if my mic is on, but I just wanted to introduce Cindy Hoskin. She's sitting at the table here. She's our new Deputy Director of Planning, Zoning, and Building, so you'll be seeing her from time to time. So just wanted to introduce her and put a face with a name
Great.
for everyone.
Welcome aboard.
So-
Welcome.
Yeah, yeah. Okay, and Commissioners? Happy New Year, everyone.
Happy New Year.
Yeah, I hope everyone's holidays was great and joyful and all that wonderful stuff. So I'll entertain a motion to adjourn.
Motion to adjourn.
All those in favor say aye.
Aye.
Opposed? Thank you.